Rules Committee come to order, and thank you very much for joining us this evening. The committee tonight will consider H.R. 469, the Sunshine for Regulations, Regulatory Decrees, and Settlements Act of 2017, as well as H.R. 732, the Stop Settlement Slush Funds Act of 2017. Consent decrees and settlement agreements during the past administration have forced federal agencies to create new rules. This method, known as sue and settle, often does not allow regulated parties to intervene in litigation until it is too late. H.R. 469 is a legislative package that strengthens the balance of powers and restores Congress's congressional authority under Article 1. This legislation imposes certain limitations on consent decrees and settlements by agencies, among other notable provisions that restore Congress's congressional authority. When Congress can effectively exercise its powers, the federal government is more transparent, efficient, and accountable to the American people. The second bill under consideration, H.R. 732, prohibits terms in the Department of Justice settlements that direct or provide for payments to non-victim third parties. The Department of Justice has systematically subverted Congress's spending power in the past by requiring settling parties to donate money to non-victim third parties, including activist groups, sometimes which are on a list that is not approved by Congress. One victim has been compensated. Deciding what to do with additional funds extracted from defendants becomes a policy question properly decided by elected officials in Congress, not agency bureaucrats or prosecutors. And without objection, I'd like to welcome the gentleman from Virginia, Chairman Bob Goodlatte, as well as the gentleman from Maryland, young Congressman Raskin, to this first panel. We're delighted to have both of you. I know both of you have spent a week back home in your district where you heard lots about not only Congress, but the work that we're doing. And so we're delighted that you're here this evening for this important work that we will perform. Without objection, anything you brought in writing will be in the record. I want to thank you both for being here, but first I'd like to defer to the gentleman, the ranking member from Massachusetts.
Well, thank you, Mr. Chairman, and I want to welcome our witnesses. It should come as no surprise that those of us on this side don't like these bills. With regard to H.R. 469, this bill was just introduced a week ago. In Title III, this bill has not had a single hearing. There's, as far as I know, been no markups. Democratic members of the Judiciary Committee and constitutional lawyers and experts have been shut out of the vetting process. Title III essentially gives the House the power to intervene, to play lawyer with full appellate rights when it doesn't like the DOJ's decision to not defend a law it believes is unconstitutional. And it isn't the House's place to determine constitutionality. That issue should be decided by the experts at DOJ and by the courts. The separation of powers is a bedrock principle in our democracy. And with regard to H.R. 732, this bill continues the Republican attacks on the integrity of the Obama administration's Department of Justice. Without any evidence to back up their claims, they are bringing yet another bill to the floor that would reduce corporate accountability by hamstringing agencies' ability to adequately address unlawful conduct or public health and safety violations. I should just point out for the record that this bill is opposed by many public advocacy organizations, including Americans for Financial Reform, Public Citizen, American Association for Justice, Consumer Federation of America, Consumer Action, National Association of Consumer Advocates, Sierra Club, League of Conservation Voters, Natural Resource Defense Council, Clean Water Action, National Urban League, and the National Council of La Raza, just to name a few. So, another week and kind of the same old, same old. So I welcome our witnesses, and with that, I yield back my time.
Thank you very much. Is the gentleman open to a question?
Happy to.
Did any of those groups ever receive this slush fund from the Department of Justice or any other federal agency?
I'm not sure what the gentleman is referring to.
You just referred to a bunch of organizations that opposed this, and I simply asked a simple question.
Organizations that are dedicated to protecting and upholding a clean environment and environmental justice and justice in general. So I'm happy to be associated with all those organizations.
Okay, so the gentleman does not know.
I don't think they have.
You
I
don't
think
know.
I'm not sure what the gentleman's referring to.
Yes, you are. Exactly the same things that we're talking about, the funds. I simply asked if any of them had received funds from, that we would now stop.
Yeah, I don't have a whole list of.
Okay, don't know. Okay, no, that's fair.
But you know what? But I think, given that fact, we ought to be very careful in how we proceed here, given the fact.
Well, that may be. I'll tell you, I would just respond back to you, and I'm not sensitive to this, and you're not either, but we may show as examples the Obama administration, but I think it's important that either administration, whether it be a Republican or a Democrat.
Yeah, I'm told the organizations that I referred to, maybe with the possibility exception of one, have not received any of the funds that you're referring to.
Okay, well, just simple question, thank you much, well, except for
So I hope
maybe.
that clarifies it.
It does, and I appreciate that. But my point back to you, Mr. McGovern, would be, I think it's in our best interest, now that we have a Republican administration, not to engage in those things either. If they were bad, if we thought that they were bad, and we disagreed, we're trying to follow up properly and do these things.
I think that's already existing DOJ policy, from what I'm being told.
Well, it might be, and I'm glad it is. So you helped me out there. My point is, I don't think it's good for either administration, and so I think that's why we're following
I
it.
guess my only other point would be that rather than dealing with these two bills, I'd like to see a CHIP reauthorization. We need to reauthorize our community health centers.
I think you've been brought up to date, and Mrs. Slaughter could, if you're not, that's an active discussion between the majority leader and the minority leader at this point, and they're both trying to work that out.
I think we're late.
Well, we might be late, but they're working on it and have not resolved that yet, so that would be a good point. So I encourage you to make sure your minority leader knows that, and I'll tell the majority leader we're interested in that. I think we are looking for something to come out of that discussion this week. Thank you very much. Well, I want to welcome the panel. Mr. Chairman, delighted that you're here without objection. Gentleman's recognized.
Well, thank you very much, Mr. Chairman. I and Ranking Member Slaughter and the other members of the Rules Committee, I'm here today in support of 4 bills: the Stop Settlement Slush Funds Act and a 3-bill package consisting of the Sunshine for Regulations and Regulatory Decrees and Settlements Act, the Judgment Fund Transparency Act, and the Article 1 Amicus and Intervention Act. All of these bills, along with the Congressional Subpoena Compliance and Enforcement Act that we are debating on the House floor today, are aimed at reinforcing and restoring the powers granted to Congress under Article 1 of the Constitution. Our system of government is a tripartite one, with each branch having certain defined functions delegated to it. The Congress is charged with writing the laws, the President with executing the laws, and the judiciary with interpreting them. The Constitution divides powers between the branches in this manner in order to guard against the abuse of power by any one branch. The separation of powers is at the core of the fundamental premise of our constitutional design, that a limited government divided into 3 branches exercising enumerated powers is necessary to protect individual liberty and the rule of law. Unfortunately, over the last several decades, Congress has allowed its powers to gradually be chipped away at by other branches. By allowing its powers to be diminished, Congress, especially this House, effectively is allowing the people to be deprived of their most responsive voice in the federal government. Through the legislation before us today and other legislation the House has actively pursued in recent years, we can begin to reestablish and enforce the limits on the authority of the other 2 branches. Although no package of bills by itself can rebuild Congress's institutional strength and restore the Constitution's integrity, it is absolutely necessary that Congress begin reasserting the powers that it has ceded to the other branches. One of the Congress's core powers is the authority to authorize and appropriate money from the Treasury. However, during the last administration, the executive branch systematically subverted Congress's spending powers by requiring defendants in settlements with the Justice Department to donate money to activist groups. In its last 2 years, the Obama Justice Department directed nearly $1 billion to third parties entirely outside of Congress's spending and oversight authority. In some cases, these mandatory donation provisions reinstated funding Congress had specifically cut. The Constitution grants Congress the power to decide how money is spent, not the Department of Justice. The Stop Settlement Slush Fund Act bars mandatory donation terms in DOJ settlements, thereby reasserting Congress's spending clause authority in this area. In addition, we also have a package of 3 bills that together further promote the restoration of Congress's Article I powers. The first bill in the package addresses executive branch negotiated regulatory decrees and settlements. Over the past several decades, consent decrees and settlement agreements increasingly have been used in federal litigation to allow the executive branch to write new law in ways that give short shrift to the requirements of the Administrative Procedure Act, Regulatory Flexibility Act, and other laws by which Congress has prescribed how agencies must conduct rulemaking. While the executive does have some regulatory authority, these settlements and consent decrees have been used to aggrandize that authority and shift regulatory priorities under the cloak of judicial authority. This subverts the boundaries both the Constitution and Congress have placed on administrative authority. The Sunshine for Regulations and Regulatory Decrees and Settlements Act limits the ability of the executive branch to collude with plaintiffs to abuse settlement decrees and settlement agreements in a manner that allows the executive to thwart laws written by Congress and increases the power of the judiciary beyond its constitutional limits. The second bill in the package, the Judgment Fund Transparency Act, increases transparency over federal spending by requiring the Treasury Department to publish data on settlements and court-ordered judgments entered against the federal government. This will allow Congress to better scrutinize and understand where federal taxpayer dollars are going. Only through the transparency this bill provides can Congress make the executive more accountable for the money that comes out of the Judgment Fund. The final bill in the package, the Article I Amicus and Intervention Act, makes clear Congress's ability to defend and assert its institutional interests in litigation that puts the powers and responsibilities of Congress into question. Currently, when the executive branch declines to pursue litigation in defense of an act of Congress, it is not required to give Congress notice in sufficient time to allow the House or Senate to defend the lawsuit before court filing deadlines have expired. In addition, the House of Representatives, unlike the Senate, does not have a statutory right to intervene or file amicus briefs in cases questioning congressional authority. This legislation ensures that both houses of Congress have adequate time and a right to intervene in litigation that questions congressional authority. We cannot continue to abdicate our powers and responsibilities to the other branches of government, weakening the separation of powers enshrined in our Constitution and threatening the very liberty divided powers were designed to protect. I would ask you to support this legislation and ask that you provide an appropriate rule. And if I may, Mr. Chairman, since the gentleman from Massachusetts raised the point that no markup was conducted on only the third portion, the third bill that's included in the package of bills, I just want to say this is very simple legislation that should not be controversial. First, the Attorney General has been required to report to Congress on DOJ's decision not to defend or assert the constitutionality of an act of Congress in litigation since this requirement was made permanent in 2002. There was a temporary requirement that predated this. All this bill does with this requirement is put timeliness requirements in place. Second, with regard to the intervention and amicus authority, the Senate has statutorily had this authority since 1978. Almost 40 years of the Senate having this authority should obviate the need for committee process on extending this provision to the House. Thank you, Mr. Chairman.
Mr. Chairman, thank you very much. Mr. Raskin, welcome. We're delighted that you're with us today. Gentleman's recognized.
Mr. Chairman, thank you very much. I'm delighted to be with you and with the Vice Chairman, Mr. Cole, and Ms. Slaughter, and all the distinguished members of the Rules Committee. I'm going to testify about H.R. 732, the Stop Settlement Slush Funds Act of 2017, and H.R. 469, the Sunshine for Regulations and Regulatory Decrees and Settlements Act of 2017. I'm afraid both of these bills would badly undermine the authority and discretion of the Justice Department and other civil enforcement agencies to protect the rule of law and to make victims of unlawful conduct whole. Now, we did not have a hearing or witnesses on H.R. 732. So the colloquy, Mr. Chairman, that you had with Mr. McGovern resembles a lot of the discussions we've been having in committee. We don't know quite what's behind the legislation, and we don't know what the contemplated or wished for impact of it is. I was very interested in the question that you posed to Mr. McGovern. I think we could all benefit from that. Is there really a slush fund that's going to advocacy groups as opposed to money being distributed to make people whole and to have groups in the community that are working to rectify the harms that were caused by particular bad actors? We just don't know that, and I think that's the key question. The bill would suddenly ban the use of comprehensive and demonstrably effective settlement agreements, even though they've been successfully employed to remedy serious legal harms, especially those caused by reckless corporate actors. For example, these settlement agreements help facilitate an effective and comprehensive response to predatory and fraudulent mortgage lending activities of financial institutions that brought the country to the brink of economic collapse in 2008 and 2009, and that led to the Great Recession. The settlement agreements in question, as far as I can tell, with two culpable financial institutions, Bank of America and Citigroup, required a donation of less than 1% of the overall settlement amount to fund foreclosure, prevention, and remediation programs to help consumers who were so dramatically affected by the mortgage meltdown crisis. As far as I can tell, that's the target of this bill, not just making individual people whole, but giving to community groups that are trying to stabilize the housing market in general in the community. Contrary to the majority's claim is, again, as far as I can determine, the Justice Department did not use any of these settlement agreements to fund so-called activist groups. Notwithstanding the production of hundreds of pages of documents by the Justice Department, along with hundreds of pages of documents produced by private parties, we've not seen any evidence that the government included unlawful or politically motivated terms in its settlement agreements with Bank of America or Citigroup. And again, I'd be happy to be disproven there, but we've not seen any evidence on it. It's just an empty claim, and I think it's a deeply divisive one when the whole country, across party lines, across geographic lines, suffered from the mortgage meltdown. The majority also asserts that these settlement agreements are used by DOJ and other agencies to circumvent the congressional appropriations process, but existing law already prevents agencies from augmenting their own funds by requiring that donations included in settlement agreements must have a clear nexus to the prosecutorial objectives of the government agency. In addition, both the GAO and the Congressional Research Service have concluded that settlement agreements that provide for secondary remediation do not violate Congress's power of the purse. Turning to 469, Title I of this bill seems to have a simple goal: to discourage the use of settlement agreements and consent decrees that successfully compel agencies to follow the law. When enacting new statutes, Congress routinely establishes deadlines for agency action, particularly when it involves public health and safety concerns. Through these deadlines, Congress requires agencies to prioritize certain actions over others. When agencies fail to meet the deadlines, as sometimes happens because of insufficient resources or other reasons, a party with standing may file a lawsuit under Section 7 of the APA to ensure that the agency performs a mandatory non-discretionary duty. The GAO refers to these suits as deadline litigation actions because they simply compel agencies to perform otherwise statutorily required actions within the designated time frame. In two studies on this matter, GAO has found no evidence that these deadline lawsuits determine the outcome of a required regulatory action, as has been alleged. As the DOJ, which represents most federal agencies, acknowledged earlier this year, these agencies are left with few defenses, if any, to these lawsuits, which is consistent with the practice of prior administrations. The department explained, quote, that a frequent outcome is a settlement agreement or a consent decree between the plaintiff that resolves the lawsuit and establishes specific timeframes under which the agency agrees to take the procedural action. In other words, I think Title I of this bill seems to be the proverbial solution in search of a problem. Titles 2 and 3 are equally puzzling to me. Title 2 overrides the Privacy Act to require publication of sensitive personal information of victims of government abuse, or unlawful conduct raising profound privacy concerns. It will force the Treasury Department to publish the names of individual victims of government misconduct compensated for their claims by the Judgment Fund, including victims of race and sex discrimination, including sexual harassment, in effect re-victimizing with a privacy violation people who've already been harmed by the federal government. Finally, Title III of 469 would facilitate the ability of whoever happens to be in the House majority to intervene in pending cases where DOJ has determined that it will not defend the constitutionality of a federal law. Not only do these provisions raise possible separation of powers problems, it's unclear why they're needed. This measure has not ever been the subject of a single hearing or markup in the Judiciary Committee. As a result, there's not been any opportunity to consider these critical and important issues and the ramifications presented by Title III. In closing, I would request that my colleagues oppose both of these measures at this point and certainly make my Democratic colleagues' amendments in order if they are to go to the floor. Thank you very much for your patience, Mr. Chair.
Raskin, thank you very much. Ms. Raskin, you seem to have done some bit of due diligence on this effort. Do you have any idea how much money we might be talking about in any given year might be at issue here?
I don't know if that information even exists. That's one of the things I was curious about. And Mr. Chairman, I can't remember if you were a state legislator before. I don't think you were, but
No,
you know,
the
I
state
spent.
of Texas was lucky. I was never elected.
You went straight to the top here. Well, I spent a decade in Annapolis, and in Annapolis, not only did every bill get a hearing, it had to get a hearing, you know? And so I've been a little puzzled by the practice of just calling up a bill, and we don't get to ask all the questions that you're inviting, which I think are exactly the questions I had when this first came up.
Good, thank you. Mr. Chairman, the money that we're talking about that might be given to these outside funds, is the presumption that the victim or victims would have been made whole and this was extra, or is that prosecutorial discretion that might be applied?
The issue is not what happens to the individuals. They were accorded whatever the Justice Department and the victims, to the extent they were parties to the case. In criminal cases, they would not be a party. Were allowed to have. So it is entirely possible that some of the funds that was diverted should have. Sorry, some of the funds that were diverted should have been instead paid to those victims. On the other hand, to the extent that this was funds that the government was recovering in the form of fines, it should go to the General Treasury so that the Congress can appropriate the funds. And finally, under no circumstances should they be directing a defendant in a case to pay money to someone who was not harmed, which is the case here. And with regard to your exchange with Mr. McGovern, the fact of the matter is, at least one of those entities that he listed as endorsing or opposing the legislation did receive substantial sums of money. With regard to the discussion about hearings, all of these bills, with the exception of the last one, which again I would argue is something that should have very strong bipartisan support, something the Senate's had the power to do for 40 years. All the others have had hearings in previous Congresses, and these issues have been aired, and they're well documented, and they're in the record.
Beautiful. Thank you very much. Chairman Cole?
Thank you. I don't have a lot in the way of questions, Mr. Chairman. I just want to welcome both our witnesses. I thought the discussion back and forth between them was good, but you won't be surprised to know the chairman persuaded me again. But I want to really thank you for bringing this legislation forward. I think this is a really important assertion, frankly, of our rights under Article I as an institution, and I think it's a really important check on the executive branch, particularly in diversion of judgments, I think, to groups, again, as you pointed out, that aren't directly harmed. That, to me, is just, that's unfair even to the person that was fined. It's unfair to the person that should be compensated, or it's unfair to the American people who ought to get the fine back to their own treasury since they had to pay for the Enforcement Act and the legal action involved. So to me, this is very common sense legislation, very important, and I just want to thank you for bringing it, Mr. Chairman.
Jillian goes back to time. Thank you very much. Mrs. Slaughter?
Thank you.
Yes, ma'am.
Thank you. Welcome, gentlemen.
Good to see you.
It's good to see you as well. Everybody, I've missed you. We've been gone a long time, seems to me. Okay, but we're ready to go. Mr. Raskin, I couldn't agree with you more on Title II of 470. I can't imagine. Mr. Goodlatte, I know you well. I don't know why you would want that kind of information. Let me read from this what it does exactly. Title II. Requires the Treasury Department, unless prohibited by statute or court order, to electronically publish information regarding payments made from the judgment fund. Such information must be made available within 30 days of the payment being tendered and include personally identifiable information, such as the plaintiff or claimant's name, the name of their counsel, facts concerning their claim, including claims for sexual harassment, medical malpractice, and race discrimination. I find that a very dangerous precedent to require that.
Well,
And I'm really like to hear your reason for that.
Absolutely. The operative words that you read are unless prohibited by statute or court order. Otherwise, these are settlements between the United States government and people who have claims against the government, and it seems to me that it'd be absolutely the right of every taxpayer in America to know what its government was settling and paying funds for, unless a court said that there's some confidential reason why this shouldn't be done, in which case the court would seal the settlement, and therefore the information wouldn't be available in the court, and it wouldn't be available and required under this statute. But anybody could go and check the records for any of these settlements
I think
that are
you could
approved
get
by the
that.
court.
You could get that same information without using their name or their counsel's name. And I think asking for that really puts them up for a dangerous circumstance.
I don't think you could. I think that you have to know who the settlement is with before you can check the records and find out what the facts are behind that settlement.
Well, I sure disagree on that, but that alone is pretty troublesome. But I know these bills have been with us before. In a previous Congress on an identical bill, a professor at the University of California, Irvine School of Law said that the bill is, quote, is what Mr. Raskin said, a solution search for problem. While there are many potential nightmare scenarios being floated around about the potential for these types of charitable payment provisions leading to the creation of federal government slush funds used to aid political allies and the like, there is little or no evidence that this is really happening. Do you have evidence that it's happening?
Absolutely. The record is replete with it, and as I say, in just the
Is it
last...
just because you mentioned that somebody who does not support the bill should not receive funds? Is that what you're saying? And not someone,
No, that
but
came
an
up
agency.
because the gentleman from Texas asked the gentleman from Massachusetts if some of the organizations opposing the legislation had been the beneficiary of Justice Department directed settlements directing the defendant in a case to pay money not to a victim of the case, but to a third party. And there indeed was at least one that had been the beneficiary of that, and they're now opposing this legislation. And I guess from their perspective, I understand why they would oppose it. But
that's not the criteria for legislation.
oh, absolutely. In the last 2 years,
No, it's
the
not.
Department of Justice...
Well, it may have been in the last 2 years.
Well, in the last 2 years, the Department of Justice, the Obama Justice Department, directed more than $1 billion to people who were not parties to litigation and were not
I understand
harmed
that as part of the
by
settlement.
the judgment.
Right. And I think that's not bad, but identifying each other is troubling to me. But let me say this. Well, we always go back to the Obama administration. Well, this is the Trump administration, and I know it's probably more comfortable for you to stay in the Obama zone, but he's not president anymore. If my colleagues are worried about collusion between administration and outside entities, let's take a look at the weekend's New York Times report on the EPA, where a chemical industry executive is now shaping policy on hazardous chemicals. They've lifted the restriction on one chemical, pesticide, that is so dangerous that even touching it is unhealthy. I worry again for the migrants who are going to be placed under the authority of that rule. They look at the White House itself, where a fossil fuel lobbyist is the top energy advisor. Is there some conflict there, you would think, maybe? They might have a point of view. The foxes are guarding the henhouse in the Trump administration. We're hearing lots of reports about waste and cronyism and the response, obviously, we know, to jam bills through the House on unsubstantiated allegations about the previous administration. So we have a lot of time doing that. Benghazi, I think we spent several years on that. But we haven't seen the same level of concern over the well-documented reports of waste, cronyism, and conflicts of interest in the Trump administration. Where's a bill to prevent them from using private jets or appointing unqualified family and friends to high-level positions, or to give lobbyists jobs that shape public policies governing the very industries that they used to represent? And how about the use of Mar-a-Lago and the emolument clause, the property that the president owns, used for meetings of the federal government? I mean, we're just swimming in it. Talk about draining a swamp, it's getting way up over our heads. And I think it's time we got off of what the Obama administration and began to look at this one, because I think we're in serious trouble here.
If I might respond.
Absolutely.
I think that none of this applies to the Obama administration. Obama administration's over and done with, so it applies to the Trump administration and future administrations. It's why I think there should be strong bipartisan support for these reforms, which restore power to the Congress and put a check on any administration, the current one and any
Yes.
future one, in terms of their shifting power from the legislative branch to the executive branch.
Mr. Raskin, what do you think of that?
Well, thank you, Ms. Slaughter. If I might, try to lift it just a few inches above just the partisan combat, there's an important question of principle here,
Yes.
which is when the Department of Justice or other federal agencies are undertaking a settlement with a confessed wrongdoer. And let's take the mortgage meltdown crisis and the abuse of homeowners' rights, because it's fresh in our minds, and also because I think it is the precipitating event here, so we should put it on the table. So millions of people have their homes foreclosed on them. Tens of millions of people lose their jobs. The economy is brought to the point of near collapse. And as I understand it, less than 1% of the overall settlement money, 99% of it went to individual homeowners, and 1% went not to activist groups who are lobbying Congress, but to community, many of them faith-based community organizations that are trying to do mortgage counseling for people and trying to help people get back on their feet. Now, that's totally within the contemplation of our civil justice system. People are to be made whole. And if you have a massive crime on the level of what took place with the mortgage meltdown crisis, you need not just individual remediation for particular homeowners, you need a comprehensive settlement that tries to stabilize communities, many of which are still reeling from what took place back in 2008, 2009. So forget the partisan implications. I just don't see why we would want to do this, regardless of whether the faith-based community group or the other community group appears to be liberal or appears to be conservative or what have you. If there's a partisan payoff going on, and this is very much in the spirit of your remarks, we want to know. And we don't want that happening on the left, the right, the center, any of it.
don't.
But I haven't seen any evidence of that, and certainly none of that was raised in any of these cases. So I just think we're going down a dangerous road when we're removing tools from the toolbox of civil justice and saying all you can do is write a check to a person and you can't do anything to stabilize the local housing market and to render assistance to homeowners.
It's sort of like the mythical voter fraud.
Well, I don't have any expertise on that right now, but yeah,
A lot
I
of
think
experts have said it's not there.
I think that again, it's a solution in search of a problem, and I agree with the chairman that there should not be partisan payments tucked into settlement agreements,
So
but I
do
just haven't seen any
Absolutely.
evidence of
Yeah.
that.
Right. Well, I continue to be very troubled by the publishing of everybody's name and what the legal case was about, in cases of things that I think that would be dangerous to the person whose name is being published. Thank you very much for your answers.
Dr. Tom, thank you very much. The gentleman from Georgia. The gentleman will be handling this evidently on the floor, and so he's going to defer his time. The gentleman from Massachusetts.
Thank you, Mr. Chairman. I would, I'm noticing there's a bunch of amendments that have been offered to the Rules Committee, and Chairman Goodlatte, I'm reading in the letter that you sent to the Rules Committee, says, I request that the committee grant structured rules for consideration of this legislation and make and order appropriate amendments to these bills. What are appropriate amendments to these bills? Anything germane, or what would you, I mean,
I
are
think
any
that,
only things you agree with, or things you, what?
I think they would be amendments that would be improving the quality of the bill.
So that sounds like only amendments that you would agree with.
Well, that certainly is the subject of debate that we'll have, whether, if the Rules Committee makes an amendment in order,
Well,
we'll
I mean-
debate those on the floor. If they don't, then they don't.
So, yeah, but I'm just trying to understand, so basically, you don't want any amendments that you don't agree with to be made in order, is that the?
I didn't say that.
Well, I'm asking, what do you mean by making in order appropriate amendments to the bill?
I think the language speaks for itself.
Well, I mean, to me, an
Amendments that
appropriate
are
amendment,
appropriate
anything
to me
anything
are
that's germane
amendments
is
that-
appropriate. That's
To
under the
me,
parliamentarians.
Amendments that would improve the quality of the bill.
Well, but
They may not be.
what if they approve the quality bill from a different perspective than what you have? I mean,
Well, then we'll have a debate on the floor
well,
about those amendments.
yeah, well, I guess what I'm trying to understand, given the kind of the lack of regular order around here, we have some pretty interesting amendments that have been offered here, and I'm just wondering whether you would say that anything that is germane, which is, which doesn't require a waiver, that's germane to the bill should be made in order so we can have a.
I wouldn't say that. I mean, that's the function of the Rules Committee to determine what
So maybe you
amendments should be made in
maybe you
order that
should-
would improve
maybe
the
you should
quality of the
allow
bill.
That legislation that make any order that Chairman Sessions wants to make an order.
I didn't say that either.
Well, would you favor making all germane amendments in order?
No, I would not.
Well, I
don't believe all
don't know
germane
why this is
amendments
such a
would
difficult
improve the
question.
quality of the
I don't know why it's such a difficult question about whether or not to allow members who offer germane amendments to have the right to have them considered on the floor. And we can't get a straight answer from you, and we usually get turned down in this committee.
But you do get a straight answer from me.
When you pass out the rule and all the germane amendments are not,
And I
are not
think-
made in order. I mean, I just, again, at some point, and I would hope that some of my Republican friends would understand the importance of regular order and how you are diminishing this institution by bringing bills to this committee under the lack of regular order that these bills came up here under, and not allowing members to offer their ideas on the House floor. I mean, we've never had an open rule in this Congress, not one. And I think should be something that you guys should be ashamed of. I yield back.
Gentleman yields back his time. Thank you very much. The gentleman from Alabama does not seek time. The gentleman from Florida. Judge, welcome.
Thank you very
Yes,
much,
sir.
Mr. Chairman. I appreciate it, and I appreciate both our witnesses' presentations. Mr. Raskin, did the Wall Street settlements require the banks to donate money to a few specific liberal organizations, or could the banks choose from a list of hundreds of organizations that specialize in foreclosure prevention and neighborhood stabilization?
Thank you very much, Mr. Hastings. Again, we didn't have a hearing on it, and that was one of the questions I wanted to ask. But I've learned, and again, it's not through the regular order congressional process, but I have learned that there was a very large list of potential donee organizations that the banks could give to. And again, I've not seen any evidence that it went to politicized operations or anything like that.
All right. That said, the chairman and Mr. McGovern had an exchange at the outset, and I got the impression when you asked Mr. McGovern, Mr. Chairman, which organizations received all the funds, my understanding is that La Raza and Neighbor Works received some of the funds. So perhaps I'll direct my question to Mr. Goodlatte. Do you know the rationale for why the organizations, not just La Raza and Neighbor Works, received all the funds?
I do not know the specifics, but I do know the generalized intent. But there comes right back to the purpose of the legislation, which is that the purpose of courts is to direct relief for particular harm caused to individuals. The purpose of the Congress is to provide generalized relief. So if relief were to be provided for consumer home ownership counseling, mortgage counseling, and so on. That should be the decision of the Congress to provide that, not somebody in the Justice Department saying, give to these organizations. And we have specific examples, including the Volkswagen settlement, where money was directed to electric vehicles, where the Congress specifically declined to provide that same money to entities for electric vehicles. Why should somebody in an administrative capacity in any agency of the federal government be allowed to bypass the will of the elected representatives of the people?
You got to be kidding me.
I'm not kidding you.
You not just about this, but I agree with you regarding the specifics that you offered, but you don't see violations of other agencies in regards to distribution of funds?
Don't see violations? I do.
Yeah. Well, what's the difference? Is there any correlation between this kind of situation or any bureaucrat anywhere making a distribution of funds? I argue all the time. And Bob, do you favor earmarks?
If the Congress authorizes through appropriations an agency to make decisions about how to distribute funds, the Congress has authorized that decision to be made. But in these instances, no action by the Congress whatsoever has taken place, and in fact, in some instances, like the one I cited, contradictory action by the Congress, and the agency nonetheless goes ahead and says, give money, if you want out of this lawsuit, give money to these entities that were not victims of the offense that was the subject of the lawsuit, and we're going right around Congress and its appropriation
All right, so
authority.
some people would argue that the two organizations that I put forward might be perceived by some as being liberal. But how about the New Christian Joy Full Gospel Baptist Church and Catholic Charities of the Archdiocese of Chicago and Catholic Charities Financial and Housing Counseling, which I don't think bear any particular labels, but the simple fact of the matter is that these funds, it appears, were distributed to charitable groups that had efficient methodologies in order to be able to accomplish the ends. And let me use the one example of money that was donated. It was that the organizations had experience in stabilization and foreclosure. So I'm at odds with you with reference to that. Mr. Raskin, what's your take on that?
Well, let's see. I guess I do have a profound disagreement with the chairman about this. And the way I would think about it, let's abstract for a moment from the housing case. Look at, for example, sexual harassment in the military, which I know has been a big deal. There was an article in the Washington Post about it today. If that went to a court could order both individual relief for people who are victims of sexual harassment, but also order that the military undertake a program to set up to say, if you are being victimized by sexual harassment, you can come here for counseling. We will tell you what to do outreach to people. That's totally within the judicial province and authority. I mean, think about what the Supreme Court and federal district courts do under educational desegregation, for example. It's not just money that goes to the kids who were put into segregated schools. It's a whole comprehensive order put into place to try to make things better for the future. Because judicial orders are not just about the past, but they're about the present and about the future as well. So a court can do it, and a court actually has to sign off on these settlement agreements. So a settlement agreement can do what a court can do, and in fact, the GAO has said that money that is paid out through a settlement agreement is not money that is being dispersed by Congress under a program. So I think we're just mixing apples and oranges there. It may be that there may have been some legislation related to some objective that Congress decided not to do, but that's wholly unrelated to the question of how you provide relief in a case like housing discrimination or fraud or predatory activity or sexual harassment.
Yeah. Mr. Goodlatte,
Well,
you, in response to Ms. Slaughter, said that there should be strong bipartisan support for these measures. If you felt that way, why didn't you have hearings on this matter?
we did have hearings in the last Congress.
In the last Congress?
That's correct.
We got brand-new people here on the Judiciary Committee now, do we not?
In some instances, yes.
Well, it seems to me, you've brought a considerable number of bills here, perhaps, in my view, more than any of the other committees in Congress. I think the number is 8 that you have brought here with zero opportunity for Democrats or your Republican colleagues to offer amendments to improve those bills. And that means for almost half of judiciary bills, Republicans have restricted open debate and shut members out of the process. And now one of the bills before us today, combined with 2 other bills into a Rules Committee print, and footnote right there, Mr. Collins said he'll have a lot to say tomorrow. I'll have a lot to say too, but I don't want to pass up the opportunity to talk directly with you. So in fact, the Judiciary Committee members had zero opportunity to hear from any expert witnesses on 3 out of 4 of these bills. Now, I don't follow the Judiciary Committee other than through what you present here substantively to go to the floor here in the Rules Committee, but it seems to me that it's a troubling pattern of the Judiciary Committee forcing bills onto the House floor without going through the full deliberative process. Now, we are naming post offices here. Judiciary bills cover a wide range of very important matters, and you've been in the minority and the majority on the Judiciary Committee, covering immigration, crime, our court systems, civil liberties, and other major issues with constitutional implications. And my view is all of these measures warrant careful consideration, not the haphazard process that we've seen here in Congress. So today I see you have an amendment, Mr. Goodlatte, which was submitted late. It'll probably be made in order. You wrote the bill, and you're still finding ways to presumably improve it. And I gather Mr. Raskin and Ms. Jackson Lee, who are members of that committee, are here, probably had some thoughts that they would have presented. And yet your committee is the worst offender when it comes to jamming bills through the House with no opportunity for amendment, or in this case, bypassing the committee process. Do you think, Mr. Goodlatte, that your bills wouldn't benefit from your colleagues' ideas or the input of outside experts? And why don't you think your colleagues would also have ideas to improve your bills?
All of these bills have been marked up, with the exception of the third portion of the bill that contains 3 different bills. And as I noted previously, that simply gives the House something the Senate's had for 40 years. We've had 40 years to observe whether or not that's a good idea. And I can't imagine why both sides of the aisle wouldn't think it would be an important power for the Congress to have. So I don't agree with your assessment of the Judiciary Committee. We're probably the hardest working committee in the Congress, with the possible exception of the Rules Committee.
You're not. This committee is the hardest working committee in Congress.
I said with the possible exception of the Rules Committee.
Let the record reflect the answer is the Rules Committee. Thank you, Mr. Goodlatte. We appreciate the feedback, Chairman Goodlatte.
I also served on the Intelligence Committee, and they work pretty hard as well. All committees do that, as I understand it. But now, in 1849, Congress passed the Miscellaneous Receipts Act. And I'm curious, Mr. Goodlatte, can you explain exactly how these donations would violate the Miscellaneous Receipts Act and should therefore be stopped? Which elements of the General Accounting Office's expert analysis is inaccurate?
Well, as the report filed with the bill indicates, they probably don't violate the Miscellaneous Receipts Act. They do violate, I think, a very important principle, which is that the Congress appropriates, not the Justice Department. And this bill makes that very clear.
Well, Mr. Collins and I will have at it on the floor tomorrow, and I'll leave it there. I yield back my time.
Gentleman yields back his time. Thank you very much. By the way, I would note for both gentlemen, and I don't know that you've had a chance or not have a chance, but many of the answers contained within the questions that we ask are on page 25 of the report that was issued. And I know the committee would want that information. The gentleman from the state of Washington, does the gentleman seek time? Gentleman does not seek time. The gentleman, Mr. Buck from Windsor, Colorado. Gentleman does not seek time. The gentlewoman from Wyoming does not seek time. Is there any other member that seeks time? I want to thank both of you for taking time. I will tell you that this is a most interesting question. It's a big question. So for a midnight reading tonight, before we get to the floor, I encourage us to read the report. I read several pages of it, but did not know the aggregate totals that were involved, but $7.2 billion and $17 billion. Deutsche Bank and Bank of America are two examples of these that stand out, at least in the testimony, notwithstanding what that aggregate total might be. Thank you very much. Yes, ma'am. Do you have anything? I want to thank both of you. Please remember we have an awesome stenographer who would appreciate anything you brought in writing to be left for her ability to finish out the record appropriately. Thank you very much, gentlemen. Appreciate it. Look forward to seeing you on the floor. Mr. Chairman, thank you for your time. Ms. Raskin, as always, enjoyed your participation with us today. Thank you very much. The committee would now welcome the gentlewoman from Texas, the gentlewoman, Ms. Sheila Jackson Lee. Ms. Lee, we're delighted that you're here, and they're going to make room there for you. We'll make sure that green light is on for you. And without objection, anything the gentlewoman has brought to the committee in written form will be available on the record. Gentlewoman's recognized.
Let me thank the members of the Rules Committee for their courtesy, and I will, listening to the discussion of the gentleman from Maryland and the gentleman from Virginia, I think that I can pose an abbreviated question and answer on my amendments. First, to the underlying bill, Stop Settlement Slush Funds Act of 2017, and with some seniority on the Judiciary Committee, acknowledge that there were hearings and maybe a markup in the last session. I think we have about a third of the new members of Congress, and certainly have a number of new members on the committee. So there was absolutely no opportunity for a hearing, experts, or discussion. It is also clear that there is no constitutional bar or statutory bar to the idea of using settlement dollars to improve the quality of life. And what I would argue is that under 732, there are a number of ways. I want to just build on the mortgage bankruptcy that was catastrophic. For example, in the African American community, it's been noted that about a third or more of the wealth in the African American community was lost with the mortgage debacle. That means that a number of organizations that could engage in mortgage counseling, whether they were faith-based or or the NAACP or the Urban League or Bankers Association of America, would be very valuable in helping. So the other aspect of it, as I'm now engaged in dealing with the aftermath of Hurricane Harvey, I think my amendment deals with the expanding, making this bill better, which I understand Mr. Goodlatte would accept. So my amendment number 1 specifically deals with exempting from H.R. 732 settlement agreements that might provide restitution in states that are not parties to the litigation. That means that if there was an environmental impact, hazardous pollution settlement, and there was a state that had this particular issue or was impacted extensionally by the lawsuit, that they could receive funds for environmental impact issues, among many others. So that's number 1, which I hope would make the bill better. Number 2, H.R. 732, my second amendment would exempt from H.R. 732 settlement agreements that pertain to payments that indirectly remediate and prevent sexual harassment, violence, or discrimination in the workplace. There is a long history of sexual harassment and certainly violence we've seen in workplace shootings and certainly discrimination. I would hope that all of us would want to be part of the overall correction of this kind of behavior, and there are a number of groups that could be actively engaged in constructive, forward-thinking ways of ceasing sexual harassment to any individual. Needless to say, the Harvey Weinstein debacle and unfortunate history, among many others, indicates to us that the problem is still not complete. So I'd ask my colleagues to make both Amendment number 1 and 2 under the underlying bill of H.R. 732. I hesitate to utilize the headline of this legislation. Frankly, it is offensive. I don't think that we can attribute to the government, which happens to be now in Republican hands, totally in the mix of giving anything recklessly. I believe that the government workers, the career workers that are in our agencies are very concerned about their duties, very respectful of their duties and their obligations to adhere to basic decorum and ethical behavior, and that they would look upon a vast list and hopefully ascertain who could best benefit from these dollars to make whatever the problem we were trying to remediate or fix, to make it better. This is probably a risky amendment or risky opposition in light of the fact that we now have a government in another party. I could argue, let's let the bill go through. But I really do think we have hardworking Americans who are in these federal agencies. When these settlements come in, they look with hopefully a fine, independent look to ensure that we make the best decisions of who can best improve the quality of life of Americans. Let me indicate in H.R. 469, the underlying bill, dealing with the Decrees and Settlement Act. My amendment is a sound revision to H.R. 469. It creates an exception for consent decrees and settlement agreements addressing harm done to individuals who were exposed to toxic substances, hazardous waste, and other environmental injustices within the scope of Executive Order 12898. 23 years ago, on February 11, 1994, President Clinton issued Executive Order 128, directing federal agencies to identify and address the disproportionately high and adverse human health and environmental effects of their actions on minority and low-income populations. So I would hope that, which is part of the basis of my amendment, is not to fall under the knife the idea of dealing with individuals who are exposed to these toxic matters. I think my amendment makes the bill better, and it is what I call the healthy exception, making more Americans healthy through allowing that exception. So I ask the colleagues to support the amendments.
Thank you very much. Is there any other?
And I ask unanimous consent to place
Without
my statements.
objection, all that will be in the record, and I appreciate that for also Mr. Stenographer, who will be able to complete the record based upon the information you provided. Thank you very much. Is there any member that would seek time with our panel? Any questions that might be available to the gentlewoman? I want to thank you for taking time to be with us, Ms. Jackson Lee, and hope that you know that just as we've extended to the gentleman from Florida our wishes and sorrow for the damages that were done, we know that you were a part of the Houston, Texas issue with the hurricane, and we hope that your district and the people of Houston are coming together a little bit better. I know that as the cooler weather comes, it's either a blessing or a curse, and I hope that you will be able to utilize the time that moves forward to the benefit. Also, congratulations on the Houston Astros and the Los Angeles Dodgers, who will be in the World Series. I was raised in Waco, Texas, to a dad that had the radio set to the Houston Astros for a number of years, and will be with great anticipation looking forward to this beautiful series that will be coming.
Mr. Chairman, if I may, it always gives me an opportunity to thank all of the various states and members of Congress who came to our aid, as we hope we will continue to have aid along with the other impacted areas. And we thank our fellow Texans as well for standing up with us. We are still hurting, and I can tell you the joy of Saturday night was immense, and the Astros are my hometown team, but they're also my congressional district, and so you've allowed me to say, "Go Astros."
Yes, ma'am. Well, I don't think in any way that we would do otherwise than to say thank you for your confidence that you give in this body to try and offer help to all the people, no matter where they might be in the islands or here in the United States of America. Thank you very much. The committee now seemingly does not have any additional members, so if there's any other member that would wish to give testimony to H.R. 469 or H.R. 732, that's what we're here for, and seeing none, this now closes the hearing portion of H.R. 469 and H.R. 732. Chairman will be in receipt of a motion from the gentleman, distinguished gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 469, the Sunshine for Regulations and Regulatory Decrees and Settlements Act of 2017, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment and amendment in the nature of a substitute, consisting of the text of Rules Committee Print 115-34, and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order only those further amendments printed in Part A of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against the amendments printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for the consideration of H.R. 732, the Stop Settlement Slush Funds Act of 2017 under structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that the amendments recommended by the Committee on the Judiciary now printed in the bill shall be considered as adopted, and provides that the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes an order only further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report. Finally, the rule provides one motion to recommit with or without instruction.
Thank you very much. You've now heard the motion from the distinguished gentleman from Oklahoma. I would defer to myself to explain more about this rule. The rule is one rule, two bills, H.R. 469, structured rule, 1 hour of general debate, makes an order 6 amendments, 5 Democratic amendments, 1 Republican, and motion to recommit. H.R. 732, structured rule, 1 hour general debate, judiciary once again, makes an order also 6 amendments, 5 Democratic amendments, 1 Republican, and motion to recommit. I thank the distinguished gentleman for bringing forth his motion. Is there amendment or discussion to that? Gentlewoman from New York.
Thank you, Mr. Chairman. Mr. Chairman, this has become a pattern, waiving rules for your Republican proposals and hiding behind the same rules when it comes to Democratic ideas. In other words, the rules of the House are written in stone for Democrats and pencil for the Republicans. And it's a double standard that we've brought up many times and that we just cannot accept. So therefore, I move the committee strike the waiver of all points of order for H.R. 469, which includes waivers of cut-go, Clause 10 of Rule 21, and Section 302F of the Congressional Budget Act. And that's a lot of waivers. And so we also want to strike the waiver of all points of order for H.R. 732, which even includes a waiver for germaneness. And I ask for a yes vote.
Okay.
And I've got a snowball's chance of getting.
Well, you know, that's
nonetheless,
never stopped any of
as-
us in this committee,
Nonetheless, she persists, right?
and that's okay. That's okay. All right, further
Yep.
discussion?
Hi, Alex.
Seeing none, the vote now be on the slaughter amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no.
Roll call?
Noes have it, noes have it. The clerk will, the gentlewoman asked for a roll call vote. The clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Burgess? No. Mr. Burgess, no. Mr. Collins? Mr. Byrne? No. Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Mr. Buck? No. Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 7 nays.
The amendment's not agreed to. Further amendments or discussion, gentleman from Massachusetts.
Yeah, Mr. Chairman, thank you. And again, I regret the last vote on the slaughter amendment because, as the ranking member mentioned, I mean, we are held to a different standard. I mean, as far as I can tell, every single one of the Democratic amendments is germane. And yet, Republicans get to play by different rules where germaneness doesn't matter. And again, I think it's worth pointing out because it shows the unfairness of the system. And I hope at some point, sooner rather than later, that the majority takes a different approach when it comes to deciding what amendments to make in order. In the meantime, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 469 by Representative Liu, number 9, which would prohibit money from being paid by the U.S. Judgment Fund to any entity that is owned by the President, the Vice President, an officer or employee of the executive branch of the U.S. government, or any immediate family member of the President or Vice President. And this is a germane amendment.
Thank you very much. Discussion?
I certainly think it's timely. Might be good if we go on record saying that.
Further discussion?
I urge you, yes.
Further arguments for the success of the argument, of the amendment? See none, the vote now be on the McGovern amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. The noes have it, noes
for a
have
roll
it.
call, Mr.
Gentleman asked for a roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Mr. Buck? Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
I'm tempted to ask Mr. Woodall if he knows what he's voting on. But I'll leave it. That'll cause him to flutter a little bit. I'm an aye.
Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 8 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion?
Yes, Mr. Chairman.
Gentleman from Florida,
Chairman,
Judge
I have an
Hastings.
amendment to the
Yes,
rule,
sir.
and I move the committee make in order and give the necessary waivers for the amendment to H.R. 732 by Representative Jayapal, number 5, which would exempt settlements that direct funds to faith-based and other community organizations that have been approved by the United States Department of Housing and Urban Development to provide assistance to current or potential homeowners, particularly for the purpose of providing foreclosure prevention assistance or instruction on avoiding predatory lending.
Okay. Discussion?
Very briefly, Mr.
Gentleman's
Chairman.
recognized.
When I raised during the questioning of the witnesses, I cited to Catholic Charities, Financial and Housing Counseling, New Christian Joy, Full Gospel Baptist Church, and Catholic Charities of the Archdiocese of Chicago, as well as La Raza and the Neighbors Organization. We all live in these communities with a variety of charitable organizations. And I don't know about in your communities, but in mine, charitable funding is off considerably. However, in the recent disasters, we have seen a healthy spike, and to my way of thinking, that's a good thing. But Ms. Slaughter and Mr. Raskin said that it seems that this is a solution in search of a problem, or a problem in search of solutions. The fact of the matter is that the organizations that receive the funds, and I read very briefly after you spoke about it, Mr. Chairman, the page 25 of the report, which does reflect billions of dollars, but at the very same time also reflects that only 1% of that money went to some pretty worthy organizations that do some tremendous work. And I challenge Mr. Goodlatte very briefly to describe to me how bureaucrats are in any better position than charitable organizations to make a determination how to efficiently and in a manner worthwhile and accountable. I just, for the life of me, I'll take the Catholic Charities Organization over a significant number of bureaucrats that are distributing money that's appropriated by Congress, and we are precluded from doing so after appropriating the money. Now, I'm one that argues that we should have transparency and accountability without question. But it would seem to me that we haven't done any harm, nor did the previous administration or the present administration do any harm when we help organizations who have credibility in the communities that they serve to be able to utilize funds under a judicial approval. And I offer this amendment with that in mind. Thank you, Mr. Chairman.
Yes, sir. I think the gentleman made a motion, and then he had a discussion. And the discussion was concerning, I believe, number 5, if I am correct.
Right.
Okay, thank you very much. Further discussion. Vote now be on the amendment from the gentleman from Florida. Those in favor signify by saying aye.
Aye.
Those opposed, no.
Mr. Chairman, I ask for.
Gentleman asks for roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Mr. Buck? Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Aye. Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 8 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion? Seeing none, the vote will now be on the motion that's offered by the distinguished gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
Ayes have it, ayes have it.
Roll call,
The
please.
gentlewoman asks for roll call vote. Clerk will poll the committee.
Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall? Aye. Mr. Woodall? Aye. Mr. Burgess? Mr. Burgess? Aye. Mr. Collins? Mr. Byrne? Aye. Mr. Byrne? Aye. Mr. Newhouse? Mr. Newhouse? Aye. Mr. Buck? Yes. Mr. Buck? Aye. Ms. Cheney? Ms. Cheney? Aye. Ms. Slaughter?
No.
Ms. Slaughter? No. Mr. McGovern?
No.
Mr. McGovern? No. Mr. Hastings?
No.
Mr. Hastings? No. Mr. Polis?
No.
Mr. Polis? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk will report the total.
8 yeas, 4 nays.
The motion is agreed to. Accordingly, the gentleman from Georgia will be handling this. The gentleman, Mr. Collins.
Mr. Hastings?
Mr. Hastings will be handling this.
Democrats. Yep.
Now, there's always a question about now, so I'm going to try and answer it if I can appropriately. Tomorrow, we'll meet at 3 o'clock to continue the work of the Great Rules Committee on FY 2018 budget resolution. Further discussion. Welcome back. This completes our work for the day.
Pete, I was with Mr. Hannah.
He's here for